You're watching the legal breakdown. So, Glenn, not that we didn't see this coming, but Trump is now trying to knock his criminal trial in Manhattan off track, and that's the one that's starting in less than 2 weeks here on March 25th. What's the strategy that he's employing right now?
So Trump's attorneys filed an 11th hour motion raising the specter of absolute presidential immunity. And they're basically asking Judge Merchan, the presiding judge in the New York state court proceeding, to just kick the case down the road, continue the trial date to a time after the Supreme Court decides the presidential immunity issue that the Supreme Court has now deigned to take up and decide. The problem is this motion was filed way too late in the game. It was filed out of time, as we say. However, judges always have the discretion to bend the rules and to, let the defense be heard on a motion, even if it's filed way late. And that's what Judge Merchan has chosen to do here. He's given the prosecutors, I believe, about 48 hours to file their opposition to the defendant's motion. But here's the thing, Brian, this motion is a dead loser for Trump in every conceivable way. Most importantly, we have to go back a little bit to when the indictment first was handed down by a grand jury in the state of New York. What Donald Trump tried to do at that point was have the case transferred from New York State Court into federal court, claiming he was a federal officer and blah, blah, blah. And that was heard by a federal court judge in New York, Judge Hellerstein. And in Judge Hellerstein's written opinion denying Donald Trump's request to try to transfer it over to federal court, Judge Hellerstein noted that Donald Trump's lawyers expressly waived any claim of presidential immunity. Here's one thing you can't do in criminal litigation. You can't waive something a year in advance of trial and then try to resurrect it and claim it again virtually on the eve of trial, because everybody sees that for what it's worth. It's nothing but a delay game that Trump and his lawyers are playing. And I have a feeling Judge Merchan will very quickly and very easily reject Trump's, attempt to try to push his March 25th trial date down the road.
Okay, well, to that exact point, regardless of how ridiculous or baseless this claim of immunity is, or being able to even have the opportunity to invoke immunity, what's to stop Donald Trump from getting that decision from Judge Merchan and then appealing to a circuit court and then appealing to the Supreme Court and then doing the same thing that he did with his other criminal trials and just waiting for the Supreme Court to take up this issue, regardless of how absurd it is on its face?
So there are a couple of issues, I think, that will prevent that from happening. First of all, remember, this is a state case. So if he did try to appeal it, he'd have to go through the New York appellate court system, and then he would have to try to jump into the federal system. And here's the thing. Donald Trump is not even claiming in this latest motion that he has presidential immunity, therefore he can't be prosecuted. He's actually claiming that because some of the statements he made and some of the tweets he posted about what he had done before he was president, things like attacking Michael Cohen for being disloyal, some of those things he did after he got elected. He's not even saying he should be immune from prosecution because of that. He's saying that as an evidentiary matter, because he was president, those statements and those tweets shouldn't come into evidence. Here's the thing. That's not what we call a case dispositive issue. So even if it was a viable issue, and it's not, it's a laughable issue, there would be absolutely no legal basis for appeals to be taken that would put a stop to the trial date. So we have to kind of separate the presidential immunity issues when it's in federal court, like in DC, and it actually involves a claim of whether a president can be prosecuted. That's the kind of thing that can go to the federal Supreme Court, and it is up at the U.S. Supreme Court. But when it's simply an evidentiary motion about whether you can introduce a president's tweets, that has nothing to do with whether whether defendant Trump can be prosecuted. Because here's the other thing, Brian, these crimes were committed when Donald Trump was a candidate. It has
Right.
nothing to do with his status as president. It has nothing to do with the official acts, even those on the outer perimeter, taken by a president. This is frivolous times three. It was largely waived. And I am pretty dang confident that there's no way this can actually put a stop to the March 25th trial date by Donald Trump taking a bunch of frivolous appeals.
You know, Judge Merchan didn't seem all too pleased, even though he allowed this motion to be filed. He didn't seem all too pleased with the fact that there was this surprise motion. Talk about what he did to prevent any more surprise motions being filed by the Trump team in the future.
Yeah, so he actually issued an order, which is a little bit unusual. It's not unprecedented. I've seen judges get really frustrated and fed up with defense attorneys when they continue to file either frivolous motions or late motions. And here's what some of what Judge Merchan put in this order. Effective immediately, the parties are hereby directed to obtain leave of the court before filing any additional motions prior to March 25th, 2024. And then he says, he puts some qualifiers on it. But if I can translate that, Brian, from legalese to English, that's Judge Merchan telling Donald Trump's lawyers, I'm tired of your bullshit. No more motions.
Now, to that point, is there anything in your opinion that might prevent this case from moving to trial on March 25th then?
Nothing. Absolutely nothing. There's no viable legal issue or claim or motion that has been made, or in my opinion, could be made by Donald Trump at this point. The judge has just precluded any more motions. So, there is nothing that I can see that would breathe any life into Donald Trump's attempt to derail that March 25th trial date. There is one other thing he might try, and I've seen defense attorneys try this in the past, and it doesn't often work. They will fire their attorneys. The defendant will fire his or her attorneys on the eve of trial, will walk into court and say, I am without counsel, Judge. I need to hire new attorneys and they need to get themselves up to speed. So we're going to need about a 6-month delay in the trial date. I have seen defendants try to do that, but the judge has to grant the motion of the defense attorney to withdraw from the case if the client tries to fire them. And what judges ordinarily do if they smell a rat, if they smell a delay tactic, they will say, I am not releasing your defense attorney from his obligation to continue to defend you and to represent you during the course of this trial. So that delay tactic will not work, Mr. Defendant.
Now, given how many efforts Trump has made thus far in both this case and in other cases, especially to delay those trials, wouldn't Judge Merchan just be able to come out and preclude him from trying any of these tactics moving forward, especially with what you said to try to fire his lawyer before they actually go to trial?
Yeah, and that's why he said no more motions, defense team. He said it to both sides, but the prosecution hasn't been in the practice of filing late motions. He said no more motions. But you know what? If you try to file a motion, it's got to be less than 1 page. And I have the option of either accepting it or rejecting it. And if I accept your motion, I may just decide it on the 1 page you file, and I may not even ask the prosecution for a reply. Listen, Judge Merchan is done. Judge Merchan knows exactly what's going on here, as does the rest of America. Donald Trump is trying desperately not to find himself a convicted felon before the November presidential election.
Okay, and let's finish off with this. Glenn, will this March 25th trial in New York be televised?
It will not. I wish it was. I mean, there is nothing like a firsthand account of what's going on inside that courtroom, because once the trial is done for the day, it's not a level playing field when the parties leave the courtroom, because Donald Trump and his lawyers and his supporters and acolytes and sycophants will step to the camera and will lie about what went on in court. We'll talk about what a great day it was for Donald Trump and how DA Bragg's prosecution has been exposed for the political witch hunt that it is. The problem is the prosecutors don't have the ability to step to the cameras and set the record straight, because prosecutors labor under a rule that says we may not talk about the proceedings while they are ongoing. And we certainly can't say anything, even in trying to set the record straight, that could impact, the ongoing criminal trial. So it's not a fair fight when there are no cameras in the courtroom. The good news is there are lots of reporters in there who will be, blogging, or who will be posting, or who will be reporting in real time about what's going on in the courtroom. But, we've watched the Georgia proceedings down there in Fani Willis's RICO case, and there's really no substitute for having, your own eyes on the proceeding and being able to judge for yourself what's actually going on.
Well, Glenn, why wouldn't those prosecutors make an exception given the extenuating circumstances of contending with a defendant who is known to just fill the void with such a barrage of disinformation and straight bullshit? Like, talk about not wanting to impact the case. Nothing is going to impact how this case is perceived more than that barrage of bullshit being spewed by the Trump team.
Brian, as much as I appreciate that sentiment, I mean, rules are in place for a reason. How many times have you heard either investigators or prosecutors say, we don't comment on pending investigations?
Every time.
We don't comment on pending cases. We let our indictments do the talking. I think that's an excellent rule of thumb. Now, given that we are in the disinformation age, courtesy of Donald Trump and the Russians and other nefarious actors who choose to flood the zone with disinformation, propaganda, and outright lies, should the Department of Justice, should prosecutors' offices like the Manhattan District Attorney's Office revisit that rule? I think they should revisit that rule because, as I say, if we don't sort of move forward in our practices, then all we're doing is ceding ground to the nefarious actors like Donald Trump and those of his ilk. All of that being said, Brian, I was a prosecutor for 30 years. And it's an area of government that is very slow to change. So I wouldn't expect to see anything different out of Alvin Bragg's prosecutors than the way they've been doing it for decades.
All right. Well, to that point, in terms of the importance of being able to follow what's actually happening in that courtroom and rebutting what will inevitably be a deluge of disinformation from the Trump team, for those watching right now, if you want to be able to follow along with this case that's coming up in a few weeks, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.